More news coming out of Guantanamo Bay, this time again from Carol Rosenberg of the New York Times, reporting on the latest events of the USS Cole bombing case. So let's get right to it. This is her article as of today. Guantanamo judge weighing heresy statements in USS Cole bombing case. At a hearing in the USS Cole bombing case this week, a retired FBI agent described what three Yemeni eyewitnesses had told investigators 20 years ago after the suicide attack on the Navy warship. According to the agent, the Yemenis pointed to a photo of Abd al-Rahim al-Nashiri, Guantanamo prisoner now awaiting a death penalty trial, as the person who had rented a safe house used by plotters of the attack. Confronted with the image on cross-examination, the former agent, Ammar Barghouti, said he was mistaken. The eyewitnesses identified one of the suicide bombers, not Mr. Nashiri, as the tenant. The rare law and order moment in a long-running case illustrated the challenge confronting the judge more than 2 decades after the al-Qaeda attack killed 17 American sailors and wounded dozens more in the port of Aden, Yemen on October 12, 2000. We just add a little bit to this. John O'Neill from the New York Terrorism Task Force here in the city led a contingent along with Ali Soufan, a retired FBI agent, to investigate this matter. And the U.S. ambassador to Yemen was Barbara Boudin, who didn't get along with John O'Neill, made some calls and wanted him out of the country, which he did. But Ali Soufan basically stayed. And Yemeni government was not so helpful in a way because the country itself is riddled with, at the time, riddled with factions of al-Qaeda and their affiliates that were located here, and their country had sympathizers with what bin Laden was doing against the Americans at the time. So to get information was a little bit a bit of a trying matter, and there weren't many people that were willing to help Ali Soufan and the FBI. Actually, prosecutors contend they have no way of finding or bringing to Guantanamo the Yemeni men and boys whom U.S. agents questioned in the days, months, and years after the attack. It is the judge's job to decide which instances mostly retired former agents can testify as stand-in for about 100 missing Yemenis. The judge, Colonel Lanny J. Acosta Jr., must determine in hearings now underway which of the hearsay statements, as they are called, reliable enough to be presented to the military judge that will someday hear the death penalty case someday, just like the 9/11 case. Someday. 22 years now. The hearsay hearings began this summer and will continue into next year, with agents searching their memories to recall interviews in Yemen in the early 2000s. Prosecutors often hand the agents the accounts they wrote at the time to refresh their recollections. Testimony has shown that U.S. agents operated under strict restrictions imposed after months of negotiations by the U.S. ambassador, Barbara Boudin, that even if Yemen were not embroiled in civil warfare, many Yemeni witnesses would never be found. For starters, Yemeni security forces located and brought the witnesses to the interviews, which were held at intelligence services compounds. U.S. agents interviewed most witnesses just once, with Yemeni intelligence representatives always in a room, usually at witnesses' side. Well, there's a problem right there. You think these people were treated fairly afterwards? Were they threatened? Were their families threatened? Was some of these people killed? Were they handed over al-Qaeda affiliates? Maybe. Agents described an at times hostile atmosphere. They were not allowed to canvass neighborhoods unescorted, nor were they able to photograph witnesses or obtain contact information to confirm their identity or to reach them later. Like I said before, it was very hard to get evidence in this country embroiled in a, faction of this al-Qaeda group in Yemen. And also, too, you had a civil war on top of it, and you had a very corrupt government. Not all of them were corrupt. So part of the judge's analysis involves why certain witnesses are unavailable. 2 of the witnesses, whom U.S. interrogators questioned in a Yemeni prison, were subsequently killed in U.S. drone strikes. The United States just killing people left and right, like they did with Anwar al-Awlaki, an American citizen. Yes, al-Qaeda recruiter. Yes, and Al-Qaeda's subordinate, yet he had American rights, and he was killed in the drone strike. Now, he has a son, Abdul Rahman al-Awlaki, who actually went to Yemen to look for his father, and he was killed in a restaurant, along with 6 others who were sitting near him in a drone strike. But you voted for Obama twice. Yemen is such a dangerous place that the ambassador works remotely. The U.S. embassy that their suspended operations in 2015. A year ago, Houthi forces broke into the compound and captured Yemeni employees of the United States, United Nations, a dozen of whom are still detained. One died in detention. The Pentagon prohibits War Corps personnel from traveling there. Navy and FBI agents have described arriving at the foundering, still burning wreck of the coal, speaking to shock survivors and them being stymied in their own efforts to investigate on shore. Yemeni security services members brought witnesses to the Americans with prepared statements on Yemeni interrogations, which were read aloud before U.S. investigators could ask questions. So you also had a lot of prepared statements that were forced. Agent Kenneth Ruhr of NCIS, who questioned port workers in a room in a prison compound in February of 2001, called the investigative conditions extremely restrictive. Each witness sat 5 feet from the investigators. Mr. Ruhr said that he or an FBI teammate would ask a question without making eye contact with the witness, and a U.S. linguist would translate. Then the Yemenis would pose the question to the witness, sometimes after questioning the question. The Yemeni general was always in the room. Pushing back against the process seemed unwise. The interviews could be ended on the snap of a finger by the host country, said Mr. Ruhr, who retired in 2014. In court this week, as Rose described interviews he conducted about 3 months after the attack with workers who heard an explosion and then looked into Aden Harbor to see thick black smoke of the destroyer. Not much of a testimony, but another unavailable witness is Salim Hamdan, the former driver of Osama bin Laden in Afghanistan. Mr. Hamdan was convicted of war crimes at Guantanamo in 2008 and sent home, but ultimately acquitted 4 years later because of flawed charges in the case. Defense lawyers say he's unwilling to testify. I can't blame him, because you probably treated him like crap. Maybe you tortured him a little bit. Prosecutors want a former federal agent to tell the military judge what Mr. Hamdan said during a pre-trial interrogation, that before the bombing of the Cole, Mr. Hamdan saw Mr. Nashiri testing explosives in Kandahar, Afghanistan. Defense lawyers have argued that Mr. Hamdan's account should be excluded from the trial because federal agents questioning him at Guantanamo, which use sleep deprivation and other abuses to get detainees to talk. You know, this is unbelievable, because this is exactly why we need to start putting these people on trial, the CIA and the contractors like James Mitchell and Bruce Jessen. We should be asking them, well, why did you do this? Knowing full well we can't use the information because you torture these people. Knowing full well you can't. And don't tell me you don't. CIA has a long, illustrious history, reports that came out throughout the 1970s, talking about how the dangerous effects of torture that doesn't provide useful information, even though the CIA lied. And then you had the Senate report that came out in 2008-9, about the rendition and torture program, reading the cable activity of the CIA regarding the rendition and torture program of detainees, like Khalid Sheikh Mohammed, Ramzi bin al-Shib, Abd al-Nashiri, Abu Zubaydah. All these are al-Qaeda affiliates, the high-ranking al-Qaeda members. Allegedly, Abu Zubaydah, the CIA said, wasn't even al-Qaeda. So we don't know who to believe. And this is the position they turned us to, right? We can't make a decision. A decision is a definitive act. It's either yes or no. And we have the evidence to show it's yes. We have the evidence to show it's no. No, they want you to think that it might be yes, that it might be no, that you don't know definitively. This is why I'm a big proponent of knowledge, not belief. I don't care to believe anything. I want to know something. Knowledge costs. Information is power. And the government doesn't want you to know anything. Lying is one thing, but to propose and to disseminate disinformation and leave it there has a generational effect. But the potential testimony of Mr. Hamdan has already been damaging to the defense. Captain Brian Mizer, Mr. Nashiri's longest-serving lawyer, left the case this month over an ethical conflict. Captain Mizer had defended Mr. Hamdan at trial and knows something about his interrogations, which could be helpful to Mr. Nashiri. But Captain Mizer cannot divulge what he knows because of attorney-client confidentiality. In 2011, weeks after Mr. Nashiri's first appearance in court, Brigadier General Mark Martins, the chief prosecutor at the time, described the war court's reliance on hearsay testimony as a necessity for a nation at war. Not war anymore. We're not at war with terrorism anymore. The war is against humanity. All this war about terrorism, the Cold War, it's never been about that. That is a distraction to what's going on here in this state. It's a war against the people. That's why there's a constant surveillance state. And in the future, what's going to happen is you're going to have people ratting on other people like they did in the Stasi state in East and West Germany. And we're already there. That's not speculation. We're already there. In fact, victims of the Stasi state have already come out in lectures and talks about how the United States are more than halfway there. That would make the Stasi state look infantile in its grandiosity. Hearsay testimony provides sufficient flexibility to submit the best evidence from genuine zones of conflict, General Martin said in a speech at the American Bar Association. Hearsay would be used at military commissions, he said, under tailored exceptions that make sense given the unique circumstances of military and intelligence operations during hostilities, and the adverse impacts on such operations that would likely result from the production of the witnesses. But that hearsay evidence is basically really not that reliable if we can't talk to these people. Did you make this statement under threats from your government or the security services? It's either yes or no. And if it's a yes, then that statement has to, that statement can't be used in court. How many of these statements would be used? Even if they saw the bombers, how can we believe them? He made no mention of the prosecutor's intent to use more than 100 hearsay statements that federal agents collected in the previous decade from Yemeni eyewitnesses under the supervision of Yemeni intelligence. Judge Blackstock, a London-bred commercial defense lawyer, said hearsay should be used in exceptional circumstances. Well, would this not be exceptional? It appears that in this case, a substantial amount of the evidence against the accused is hearsay. And if that is permitted, it will cast doubt on whether the trial could be fair, said Ms. Blackstock. That's true. Who observed this week's proceedings on behalf of a British human rights organization. That's the end of the article. That's right. Because if they're allowed to use hearsay evidence, which most of these statements, it seems, are coerced, forced to say a certain narrative because they feared that the Yemeni intelligence services might kill their families or do harm to them, then that statement cannot be used in a court of law. And because of Barbara Bodine, the Yemeni U.S. ambassador at the time, who really was obstructing the Federal Bureau of Investigation's investigation into the USS Cole attack, we also have to contend with that as well, a lack of information, a lack of cooperation, because they didn't like John O'Neill, who, if you didn't like him, I mean, that's one thing, but you can't say that he wasn't probably the best investigator, the most competent investigator when it comes to Arab fundamentalism between 1998 to 2001. and regretfully, he was killed in the North Tower of the World Trade Center on September 11, 2001. I don't know if this trial will even be successful. And it just seems that, the weight's against us, but we have to keep trying, and we have to keep reporting the news without bias, without prejudice. Thank you for watching, guys. I'll see you in the next video.